a very warm welcome to all of you. Today, we present before you the thorough newspaper analysis for Saturday and Monday, which is the 16th and the 18th of March 2024. Now, let's quickly head to the agenda sheet and have a look at the discussion points for today. So, first of all, for the editorial segment, again, we've taken up an article from Indian Express, and the title of this article is it illegal to watch child pornography? The Supreme Court, it has now decided and agreed to hear petition in this respect. So the court essentially is addressing a challenge which is put forth against an order of the Madras High Court. This is again a very important topic, and it involves a certain element of sensitization that we as a society has to undergo so far as this entire matter of child pornography and using children for the larger purposes of sexually exploiting them. It needs to be addressed. So I believe this is a very important topic, and we should be aware of the legal position so far as this topic is concerned. Now, secondly, we talk about the news updates for the day for both of these days, and this is going to be followed by the last segment where we have 3 updates from the Apex Court and 1 from the Honorable High Court of Allahabad. So now let's proceed and have a look at the article for discussion today. So the title of it, I would like to again reiterate. It is it illegal to watch child pornography? The Supreme Court hears petition. तो सबसे पहले हम इसकी कॉन्टेक्स्ट की बात करते हैं, एज इन सुप्रीम कोर्ट के पास ये पेटिशन कैसे आई. सो एसेंशियली मद्रास हाई कोर्ट ने अपने एक ऑर्डर विच डेट्स बैक टू 11th of January, उसमें मद्रास हाई कोर्ट ने ये हेल्ड किया था कि इफ यू आर समबडी हु इज मेरली डाउनलोडिंग एंड वाचिंग चाइल्ड पोर्नोग्राफी, तो ये एक ऑफेंस नहीं होगा under the POCSO Act, which is the Protection of Children from Sexual Offences Act of 2012 and the Information Technology Act of 2000. Now, when the Supreme Court was approached, the court now has agreed to hear this plea challenging and impugning this order of the Madras High Court, and a bench of Honorable the Chief Justice of India, D.Y. Chandrachud, and Honorable Justices J.B. Pardiwala and Manoj Mishra, they've now termed and called this particular order as atrocious. The court has also sought a response from Tamil Nadu government on this petition, which is filed before the Apex Court. Now let's see what is this petition, what are the parties that are involved, and what is broadly their line of argument. So 2 child welfare NGOs, one of which is Just Rights for Children Alliance, and the other one is a New Delhi-based NGO called Bachpan Bachao Andolan. They've clubbed together this petition and approached the Apex Court. They've said that the Madras High Court's ruling that watching child pornography, it does not fall within the scope of POCSO Act. It could give a harmful impact on child welfare. So this is their contention. Further, it has been argued by the council representing these petitioners that the order, it was also contrary to the established law in this regard in our country. Taking note of the arguments, the Supreme Court has issued notice on the plea and lists this entire matter for further hearing on 5th of April. So, जब further hearings होगी, तो we are going to keep a tap of it and we'll update you later as to what is the progression before the Supreme Court. Now let's deal with the High Court's order in detail, and here we'll have a look at 2 provisions, one from the POCSO Act and another one from the IT Act. तो POCSO Act के लिए concerned provision होगा section 14, and Information Technology Act में हमारे पास concerned section होगा section 67B. So we'll have a look at both of these sections, and then we'll understand whether the High Court's ruling, as far as our understanding is concerned, whether it makes sense or not. So let's see. I would like to read the portion that's hidden behind my video. So the heading says, what did the High Court rule? So in the case of S. Harish versus Inspector of Police and another, the Madras High Court, it quashed criminal proceedings initiated by police concerned against a 28-year-old man. He was booked under the POCSO and IT Acts for downloading child pornography videos from the internet. So essentially, this is what has happened. The High Court was approached in a quashing plea by a man against whom these proceedings were initiated under the relevant provisions of POCSO Act and IT Act. So the High Court, while quashing these criminal proceedings, the single judge bench of Justice Anand Venkatesh ruled, and I would like to quote, the materials that have been placed before this court, they do not make out an offence against the petitioner under Section 67B of the Information Technology Act of 2000 and Section 14, subsection 1 of the Protection of Children from Sexual Offences Act of 2012. Justice Venkatesh also said that although Section 67B of the IT Act, it is very widely worded, it does not cover cases where a person has merely downloaded child pornography on his electronic gadget and watched the same without doing anything further. Now let's see what are these sections. So first we take up Section 67B. Section 67B, it punishes all of these acts. What are these? It punishes the publication, the transmission, the creation of material which depict children in sexually explicit acts in electronic form, and the punishment is with 5 years to 7 years of imprisonment and a fine which can extend up to rupees 10 lakh. So this is the subject matter of 67B. We'll deal with this provision later as well. Now let's proceed further and see what Section 14 of the POCSO Act has to offer to us. So देखिए Section 14 जो POCSO Act का है वो prescribe करता है punishment for using a child for pornographic purposes. Subsection 1 of this particular provision states, and I would like to quote it, whoever uses a child or children for pornographic purposes, they shall be punished with imprisonment for a term which shall not be less than 5 years and shall also be liable to fine. And in the event of second or a subsequent conviction, then the punishment is going to increase. So then they shall be imprisoned with a term or imprisonment for a term which shall not be less than 7 years, and there is also a mandatory imposition of fine. So observing that this the Gen Z generation Z children, they are grappling with porn addiction, and the society must properly educate them. Instead of punishing these kids, the Madras High Court advised the accused to attend counseling if he's still afflicted with this sort of an addiction. Also, the Madras High Court relied upon a Kerala High Court ruling. So what was this ruling of the Kerala High Court? देखिए केरला हाई कोर्ट ने essentially ये हेल्ड किया था इस केरला हाई कोर्ट की एक प्रीवियस जजमेंट एंड रूलिंग में that if somebody is watching any sort of pornography content within the bounds of his private space, then that would not constitute an offense under a provision of the IPC. What is that provision? ये आपने काफी बार पढ़ा होगा, which is section 292. So केरला हाई कोर्ट ने ये रूल किया कि if a person, अगर वो कोई pornographic या sexually explicit content is being consumed by the person within the bounds of his private space, then that would not constitute an offense under 292 of the IPC. Section 292 of IPC, it pertains to the sale of obscene books, objects, and all of these materials of the like character. The provision, it states that for something to be obscene, this particular content and object, it must be lascivious, it must be prurient, or it would deprave or corrupt someone. So it must have the tendency of depraving or corrupting the mind of somebody. However, since these terms, they are not clearly defined, there is no room for interpretation by the courts. The order, it stated. Now let's see, by making a reference to the provisions, which is 67B of the IT Act and 14 of the POCSO Act, as to whether, what is the position of law in India so far as the entire matter of child pornography is concerned. So, see, although the Kerala High Court ruling, it rightly said that watching any sort of explicit content, it isn't an offense so far as it is done, within the bounds of your private space. The situation differs in cases when children are concerned and child pornography is concerned. So why is that? Because Section 67B of the IT Act, it punishes all kinds of acts pertaining to child pornography, including watching a matter which, shows children in explicit acts. A close look at the provisions of Section 67B, it is going to reveal to us that it punishes 5 categories of people who are involved in child pornography. So what are those categories? Let's see. The first category of persons would include a person who is publishing, who is transmitting, who is causing children pornographic material to be published or transmitted in electronic form. So this would be somebody who is engaged in dissemination, in transmission or publication of the material that has already been prepared. So first category of person would be that. The second category of persons penalized under this provision pertains to those who create text or digital images or who collect, seek, browse, download, advertise, promote, exchange, or distribute such sort of material in electronic form. So the second category would involve a variety of people who are, let's say, creating text or digital images, who are collecting also, who are seeking, browsing, downloading, so they're consuming also, advertising, promoting, exchanging, or distributing such material. So second category would include all three, these broadly three categories: those who are creating, those who are disseminating, those who are consuming also. So the third category concerns those who cultivate, entice, or induce children into online relationship with one or more children for sexually explicit acts or in ways that may offend reasonable adults on the computer resource. So this is somebody who is enticing, soliciting these children to get in relationship with each other for the broader purpose of their sexual exploitation. Similarly, the fourth and the fifth categories, they pertain to persons who are facilitating child abuse online and those recording in any electronic form their abuse or that of others relating to sexual explicit acts with children. In June 2021, please note, the Madras High Court in the case of PG Sam Infant Johns versus State had to deal with a case where the accused had browsed, downloaded, and transmitted child pornographic material by using a SIM card through his email and Facebook account. So this was a factual scenario that the High Court saw in 2021, June of 2021. Now, in this ruling, the single judge bench of the High Court again noted that there is no provision in the law that prohibits viewing pornographic material and content privately. There is, however, a distinction between pornography and pornographic material that involves a child. So the bench then said that the latter, which is child pornography, it falls outside the circle of freedom due to the existence of Section 67B of the IT Act, which penalizes every kind of act pertaining to child pornography, and concluded that even viewing child pornography it itself is an offense, and as a result, the accused was held guilty. So this is going to be a very important update for us to follow, and we'll definitely cover it later on when the matter is before the Supreme Court. And now we proceed to the national news category for today. All right, so now let's proceed to the national news, and here this is the very first update. So 2022 Human Development Index, it has registered a progress so far as the ranking of India is concerned. Now here in this news, we'll see two important indexes. One is the Gender Inequality Index of 2022, and the another one would be the United Nations Human Development Index. Two rankings we'll have a look at. So as far as the Gender Inequality Index of 2022 is concerned, according to the Human Development Report, which was released by UNDP, India ranked at 108th position out of 193 countries, and this is the 2022 ranking. So currently the ranking is 108th out of 193 countries. However, this is a jump of 14 positions. So in 2021, our ranking was to 122 out of 191 countries. Now, so far as the United Nations Human Development Index is concerned, our current ranking is 134, and this is out of 193 countries. In 2021, our ranking was 135, which out of again 191 countries. So here there's an improvement of 1 position. But in the Gender Inequality Index, the improvement is of 14 positions. Next up is this update. RBI bars Federal South Indian Bank from issuing co-branded credit cards. So following the directions released by the Reserve Bank of India, private sector lenders, Federal Bank and South India Bank, they've stopped issuing co-branded credit cards to new customers on account of regulatory deficiencies. And this entire direction, it came about by virtue of this notification. So the bank, it has also added that it will continue to service the existing customers, but so far as the new customers are concerned, there is going to be a bar on issuing these sort of credit cards. Mumbai, it has won record extending 42nd Ranji Trophy. Mumbai has won record extending 42nd Ranji Trophy title as they defeated Vidarbha by 102 runs in the final at Wankhede Stadium in Mumbai. And this is Mumbai's first Ranji Trophy title since the year 2016. I'm sorry. So now let's talk about this particular trophy title. Ranji Trophy, it is named after one of India's first Test cricketers, who is Ranji Singh, who played for England and Sussex. Largely regional in nature, this trophy, it can be summed up as a domestic first-class cricket where a series where various regional teams, they play against each other. The first series, it was announced in the year 1934. You may make a note of this year of announcement. And the initial fixture, it took place in 1934-1935. Maharaja Bhupender Singh of Patiala, he donated the trophy. Okay, next up is this update, which we covered in our Saturday's TNA at length. I would like to read it out. I think my video must be covering the heading. Nath Kovind-led panel, two-step approach, single electoral role. So the high-level committee, which is led by former President of India, Nath Kovind, it has submitted its report to the current President of India on one nation, one poll or one election, which recommends a two-step approach of holding simultaneous elections for three tiers of government, the Lok Sabha, the legislative assemblies, and the local bodies, which is the panchayats and the municipalities. It envisaged a two-step process where the first step, it should be to simultaneously hold elections to the Lok Sabha and the state legislative assembly. We've covered at length this entire matter. So in case you want to get more insight into this topic and you did not see our previous TNA, I would highly encourage that you go back and watch that. In the second step, panchayat and municipal elections, they should be synchronized in such a way that they are conducted within 100 days of the conduct of the simultaneous election at the national and state levels. Next up is this update. The Ministry of Home Affairs, it has ranked among 10 top ministries in grievance redressal assessment index. The Home Ministry, it is consistently ranked amongst the top 10 ministries in 2023-2024 in the grievance redressal assessment index, performing well in all 15 specified indicators. Only 10% of grievances resulted in appeals, which is one of the lowest among all the ministry grievance assessment results. Another update with respect to, okay, this has already been covered. I'm sorry, this has been repeated. Okay. Next is this update. Indian Express Ritika Chopra, independent journalist Grishma Kuthar, they won the Chameli Devi Award. Indian Express's Chief of National Bureau, Gitika Chopra, and independent journalist Grishma Kuthar, they've been jointly awarded with Chameli Devi Jain Award 2024 for Outstanding Woman Media Person of the Year. Now let's talk about this award itself, as in why was this constituted, what is the background of its name, and the recipients or the earliest recipient of, and all of those. So set up by the Media Foundation in the year 1908, Devi Jain Award for Outstanding Woman Media Person of the Year, it is named after Chameli Devi Jain. She was a freedom fighter, a community reformer who was imprisoned during India's independence movement. The first award, it was given in the year 1982, And since then, it has been presented every year to those practicing impactful journalism in fields such as social development, politics, gender justice, human rights, conflict, and consumer values. Next is an update from Thailand. Researchers camping in Thailand, they discovered a new scorpion species with 8 eyes and legs. Okay, so just a moment, please. In Krachan National Park, which is in Thailand, a team of researchers, they've made a discovery. So what is that discovery about? A previously unknown species of scorpion, scientifically classified as it is scientifically classified as Euscorpius krachan. The newly discovered scorpion, Euscorpiops krachan, it takes its name from the very park that unveiled its existence. The species, it belongs to the subgenus Euscorpiops, stands out for its very, diminutive sort of size, which means it is comparatively lesser in size when compared to the others in the same subgenus. So it stands out for the diminishing size compared to its counterparts in the same subgenus. Another update in the sports segment, RCB, it wins its first title across leagues. Royal Challengers Bangalore, RCB, it beat Delhi Capitals to win the second season of Women's Premier League. Royal Challengers Bangalore, it has won its first title across franchise leagues when it beat Delhi Capitals by 8 wickets to claim the second season of the Women's Premier League at the Arun Jaitley Stadium. Bangalore-based franchisee, it is yet to win a title in the Indian Premier League. Now this has brought us to the international segment for today. China, Iran, Russia wrap up joint naval drill. China, Iran, and Russia, they've wrapped up their joint naval drill on 15th of March, with the Chinese and Russian naval vessels departing from Iran's Chabahar port and sailing back to their respective countries. The trilateral naval drill, which is dubbed or called as the Security Bond 2024, it took place from March 11th to 15th of March. With the theme of creating peace and security together, the joint naval drill, it focused on anti-piracy and search and rescue operations. Next is an update from Palestine. Palestinian president appoints long-time advisor as the prime minister. President Mohammed Abbas, he has appointed Mohammed Mustafa as the Prime Minister of Palestinian Authority, which runs part of the occupied West Bank. Mr. Mustafa, a US-educated economist and former senior World Bank official, is long-time advisor to the president. His predecessor, Mohammed Shatayeh, he resigned 3 weeks ago, citing emergency reality in Gaza Strip. Now, this has brought us to the legal development segment. And first, we have an update from the Supreme Court. And this is important. Why? Because you must have witnessed that the check dishonor or check bounce cases, they are at its peak. And there are a lot of these litigations going on in the lower judiciary, particularly. So with respect to that, Supreme Court has laid down certain parameters. So the Supreme Court has observed that mere filing of check dishonor complaint under the Negotiable Instruments Act, it would not grant a right to a complainant to seek interim compensation under Section 143A, subsection 1 of the NI Act. Why? Because the power of the court to grant interim compensation is but it is discretionary, and it needs to be decided after prima facie evaluating the merits of the case. Section 143 capital A of the NI Act, it provides power to the court to direct interim compensation to the complainant, and it was inserted through an amendment to address the issue of undue delay in final resolution of check dishonor cases. There used to be a lot of delay, and as a result, and to address that, this particular provision was inserted by virtue of an amendment. So now let's see what are the parameters which have been laid down by the court. So the court said that courts will have to prima facie evaluate merits of the case made out by the complainant on merits of defense which is pleaded by the accused in reply to the application. The financial distress of the accused, it can also be a consideration. Further, a direction to pay interim compensation, it can be issued only if the complainant makes out a prima facie case. If the accused defense is prima facie plausible, then the court may exercise discretion in refusing to grant interim compensation. If the court concludes that a case is made out to grant interim compensation, then it will also have to apply its mind to the quantum of interim compensation to be granted. While doing so, the court will have to consider several factors. For example, the nature of the transaction, the relationship, if any, between the accused and the complainant, and so on and so forth. That is to say, factors of the like character. The parameters, they are of course not non-exhaustive, and others can also be included in this entire list. The name of this matter is Rakesh Ranjan Srivastava versus the state of Jharkhand and Nath. Moving on, this is again an update from the Supreme Court. So the Supreme Court has recently observed that any change to the eligibility or qualifications prescribed in the recruitment advertisement in the middle of the selection process, it is an impermissible exercise, and therefore it would amount or tend to amount to denial of opportunity to the candidate who is eligible to be selected as per the original advertisement. The name of this matter is Anil Kishore Pandit versus State of Bihar and others. Again, an update from the Supreme Court. So the Supreme Court here has said, this is an important update. So essentially, the matter was before concerned the Haryana government, Punjab and Haryana High Court, and then the Supreme Court. So let's see what is this entire case about. So the Supreme Court has recently underscored, it has highlighted that governor of a state can only consult the High Court of the state concerned in the matter of the appointments of district judges in terms of Article 233 of the Constitution. So if the governor has to appoint the district judges, then the body that it has to consult is the High Court of the state. Let's see what Article 233 has to say. So clause 1 of this article, it stipulates that the appointment of persons to be district judges in the state and their posting promotion, it shall be made by the governor in consultation with the High Court exercising jurisdiction in the state. See, essentially, holding so, the court found fault with the Haryana government. So what did the Haryana government do? It sought a legal opinion from the union government regarding the recommendations made by the Punjab and Haryana High Court for appointments in the district judiciary. So the Punjab and Haryana High Court made some recommendations. So the Haryana government, instead of acting on that and accordingly proceeding further, it rather sought an opinion from the union government. So here in this respect, the Punjab and Haryana High Court slammed the state for seeking the union's opinion, terming it as, quote unquote, serious assault on the independence of the functioning of the High Court. And in this respect, the Supreme Court has also said something on the lines of the High Court only, and said that the governor can only consult the High Court and not the government at the center, so to say. So the name of this matter is Dr. Kavita Kambuj versus the High Court of Punjab and Haryana and others. Next, we have an update from the Allahabad High Court. So the Allahabad High Court has held that a legal marriage between two Hindus, it cannot be dissolved by way of a compromise which is entered into at the time of proceedings for maintenance under Section 125 of the CRPC. The court held that such marriage, it can only be dissolved by a decree which is passed by a competent court under the legislation which is governing marriage between Hindus, which is here the Hindu Marriage Act of 1955. The name of this particular case is Rajni Rani versus the state of UP and others. So that's all we have for TNA for today. Thank you for being with us. And again, the quiz link would be available in the description. And in case you want to get access to the free study material that we curate or the TNA slides, then you have to follow us on our Telegram. So join the Telegram channel. For doing so, you can scan the barcode here or click on the link which is given in the description. These are the point of contacts in case you want to get in touch with LawSikho. Thank you so much for being with us and have a good day.